This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Town of Queen Creek. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. Whether you're working from home or doing kindergarten from home, we want to remind you that we're in this together.
City of Tempe. We are in this together.
Before we get started, I'd just like to do some introductory remarks. My name is Beth Mulcahy, for those of you who may not have watched one of our presentations before, and I'm with the Mulcahy Law Firm, and I'm the managing partner and senior attorney of the Mulcahy Law Firm located in Phoenix, Arizona. And I've enjoyed practicing community association law for the past 23 years, and our firm currently represents over 1,000 planned communities and condominium associations throughout Arizona. I've also served on my HOA board for many years as well. So I hope I bring an interesting and unique perspective to these classes that I'm helping with for the Neighborhood Services Virtual HOA Academy. First, I'd like to just acknowledge all the different cities, towns, and municipalities that are working with us this morning to provide free education to board members, managers, and homeowners. I'd like to give a special shout out to our partners for the Virtual Fall HOA Academy. And those different cities that we are working with for the neighborhood services departments are Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, Tempe, and the town of Queen Creek. And all of them have organized a special virtual HOA Academy to provide free information during this time when we can't meet together in person. And this is class number 4. And we have one more class in this series after this class today. In case you've missed our previous classes, I'd just like to mention that you can find the recorded video on my firm's website at mulcahylawfirm.com under the videos pages. A link will also be posted in the comment section of this video at mulcahylawfirm.com videos. We are honored to work with the many different representatives from the neighborhood services departments across the valley year after year. I've been working in the capacity of providing free education for the past 20 years to many different municipalities and cities, and they truly realize how important education and teamwork is year after year as they provide excellent programming that's free for board members, managers, and owners who live in associations. And this Fall HOA Academy, which we pivoted and did as virtual, is truly no exception. A lot of planning went into it, and so I would like to give a special thank you to them. And I think it kind of goes with the theme of this Virtual HOA Academy that we've put together, that we are all in this together, and truly we're better together when we're sharing information and ideas and providing helpful information to all of you. So our 2 topics today are really great topics. The first topic is, how can we survive and thrive during this pandemic, which seems to be lingering on month after month? And what are some pivots that we may need to be thinking about in the next quarter and into the first quarter of 2021? And then we're going to turn the page and talk about what federal laws do your board members and owners and managers, federal laws do you need to know about that apply to community associations, such as planned communities and condominiums? And so we'll give an overview of what those federal laws are and what you need to keep on your radar so that you don't violate any of them. So first, let's start out with our introductory remarks. We're starting to see publications, newspapers, online publications talking about a second wave of COVID-19 hitting at some point. Likely this winter, as some people are needing to be going inside and spending more time inside. And reports are coming out of Europe already that indicate that Europe may already be experiencing the second wave right now. And countries in Europe have started to enact lockdowns in certain areas and stay-at-home measures in an effort to slow the spread. I think we've also seen that in New York City. Is this a sign of what's to come in Arizona? We don't really know. That's one of the hard things about this pandemic, is that there are so many uncertainties that we are all, trying to manage. But what I do know for certain is that we can plan ahead, and we can take measures to be prepared for a potential second wave. And even if there isn't a second wave, what are some things that we can continue to do so that the associations can manage and thrive, even if the situation, stays the same with the pandemic for a few more months, or maybe 6 months, or maybe even through 2021. So let's talk a little bit about what are some different suggestions that our firm has as we continue to navigate the pandemic. The first thing that I would just like to reiterate is communication. The boards that are communicating with their residents and the managers that are encouraging boards to communicate with their residents, they are going to be the most successful associations during this time. So communicate timely and often with members as to, what's going on in your community. If you have, any sort of an outbreak in your community, it's of utmost importance that you're communicating on that. You can communicate via putting things on your website. You can send out newsletters on email. Some different associations are using the platform Constant Contact to send out mass emails to their community. You can put it on social media, next door, direct emails to owners in your association. It really just depends on what works for your association. So communicating timely and often is a really important thing so that people feel that they're aware of what's going on in the association. There may need to be common area closures in the future. We don't honestly know what the future is going to hold with the pandemic in Arizona. And if that happens, I think we all learned some great lessons, right, through the first wave of closing down our common areas. Make sure that you're thinking about that as different state regulations are coming out, and make sure that you're tuning in to our firm's social media pages. Anytime there's a major development, I can assure you that our firm will be talking about new governmental orders or anything that may pertain to associations as we navigate the pandemic. So be sure to sign up for our mailing list or be checking our web pages. Also, be sure to be checking the neighborhood services, web pages through each of your respective cities that you live in. There is a wealth of fabulous information for homeowners, tenants, board members, managers on all the wonderful resources that your cities are providing to you right now. So I would encourage you to frequently check out those pages, especially as circumstances change in Arizona. Leadership, another really important thing. During this time, it's important that we have strong leaders, and they need to be calm and look at the different challenges that they're facing in your community and steady. No knee-jerk reactions. Make sure that your board and your leaders are reaching out to your trusted advisors when questions come up that you don't know the answers to, or you're curious as to whether you might be able to implement something. We have free cheat sheets, videos. We are announcing all of our Facebook Live seminars when large developments occur. So continue to stay connected with us, because we're here to keep you posted on any developments that may be happening on a state level that you may need to be aware of. Also, stay tuned for future neighborhood services seminars. We're hoping that we will continue on with a virtual HOA Academy this spring. 2 weeks ago, our firm did a survey where we asked different people. Over 200 respondents responded to our survey. And we asked you what topics you want to see in the future for your free education classes that the neighborhood services departments may be providing to you in the spring. And so we have a ton of great information from the over 200 people that responded to that survey. And also you provided us great information about how many of you have had virtual meetings, how many of you have not yet had a virtual meeting. How many of you have had your annual meeting in 2020, which, as you know, is a requirement under Arizona law? And we encourage you that if you have questions about running a virtual meeting, or you haven't yet done it, we encourage that you please reach out to our firm. We have great resources. We have videos that can assist your board. We have a cheat sheet on conducting a virtual meeting. And we even can help you get online and run your annual meeting if you need help this year. or teach you how to have the virtual Zoom meeting if you haven't had one yet. So please keep that in mind. There are a lot of resources out there for that. And we'll be announcing what classes that our firm will be teaching, hopefully in conjunction with the different neighborhood services departments, likely in the end of November, beginning of December. We'll probably be putting out our curriculum for those classes. So stay tuned. We've got a lot of great information that you are asking for us to teach. So we're making sure that we're being responsive to that survey. Another really important thing on how to survive during the pandemic is we really need to keep an eye on delinquencies, owners that aren't paying assessments. So if we look at some, factual data in our industry right now, so the National Chapter of Community Associations Institute has done surveys throughout the pandemic. And so, we've been monitoring those surveys, and thousands of people are responding to those surveys throughout the country. So this isn't Arizona specific, but I think it gives us some great information that we need to keep an eye on. So if we're looking at delinquencies, the national survey done by CAI said that between February 2020 and August 2020, there was a slight increase in the delinquency rate in associations. So in February 2020, the delinquency rate was about 8%. So about 8% of the homeowners and associations on a national basis were delinquent in the payment of their assessments. So by August, it had increased only 1%, which truly is amazing, right? I mean, we're in a pandemic, and a lot of people have lost jobs. A lot of people are having serious financial difficulties. And so it's surprising and wonderful that we only saw a 1% uptick, between February and August of increases in delinquencies. Now, if you look at the survey that our firm did 2 weeks ago of 200 Arizona associations, I want you to note that we saw that delinquencies are now higher in Arizona. So 15% of respondents in Arizona to our survey said that the number of delinquent owners has increased since March 2020. So, we're seeing, 8% at the beginning of the pandemic on a national level, then it went up to 9% in August. Now in mid-October, we're seeing 15% of the respondents in Arizona. So it's something you need to keep an eye on. Your association, especially your treasurer and your board of directors, should be looking carefully at the delinquency list for your association every month. And you should be asking your management company to provide, okay, what were the numbers last month and what are the numbers this month in terms of total delinquency, dollars delinquent, and then start analyzing that every month, because it's very possible with a lot of these government funded programs no longer providing assistance and unemployment, possibly running out for certain people. It may be a natural progression that the people stop paying their assessments. So you need to keep an eye on that. And the suggestion to you, if you are seeing an uptick in delinquencies in your association, is you need to be proactive and reach out to those homeowners earlier rather than later. And so some suggestions that we have right now for every association would be make sure in any communications that you're sending out to your owners that you're communicating with them about the importance of paying assessments in a timely manner to your association. So, talk about it at regular board meetings, talk about it at an annual meeting. Make sure you're putting it on your webpage, in your newsletters, and any communication that you're sending out to your homeowners. It's good, just a reminder that it's important to pay assessments. Another thing is that you need to follow a collection policy. So if you have owners that are not paying assessments in a timely manner, you need to set up a policy and then stick to it for all owners. What we don't want to have happen for associations is that we start to see the uptick in October, November, December of 2020, and the associations do nothing about it for 6 months, 9 months, 12 months, because you're losing valuable time to get the owners to pay the assessments. And so we have a really great cheat sheet that our office is pinning in the comments section of this Facebook Live on secrets of effective collection of delinquent assessments. If any of you are seeing an uptick in delinquencies, I highly encourage you to take a quick peek at that cheat sheet because it has great information. And most importantly, act in a timely manner. Make sure that you're leaning the properties if they're delinquent in assessments in a timely manner, whether it's 60 days, 30 days, 60 days, 90 days, whatever policy your association adopts. And then think about at what point should this file be turned over to the attorney for collections. And remember that there's a law that went into effect now a couple of years ago that requires the association send a specific letter to the owners letting them know that, hey, your file is going to be turned over to the attorney in 30 days. And so make sure that your management company has that letter and is sending that letter before it's sent to the attorney. Otherwise, when it gets turned over to the attorney, we have to send it back and you have to send that letter before it can be turned over to our firm. And that's just state law. Now, if you're a self-managed association and you need a copy of that letter, please reach out to me. We'll give it to you for free so that you have that available and that you're following the law as you're progressing through with these delinquencies. And then once it gets to the attorney, if you have delinquent owners, make sure that your attorney is being careful on how to pursue the files. Our firm always does a collection evaluation at the beginning of the file. And so we look at the owner's credit and we print out back to you what our research shows. Are they employed? Are they behind on their mortgage or deed of trust? What does their credit look like? Do they owe money to other people? Are there judgments against them? What's the value of the property in comparison to how much they owe on it? And we give that information back to you and provide you with our recommendations on the best way to get the owner to pay. And so that could be a recommendation to foreclose if they have equity in their property, or it could be a recommendation to get a personal judgment against them if they're employed. We can garnish their wages. So just kind of a quick refresher on this. If you are seeing an uptick in delinquencies, make sure that you are proactive on that and don't brush that aside for 6 months later, because the problem is only going to get worse. If we're anticipating that we're going to see more delinquencies in 2021, and so we want to make sure that the boards are being proactive early to collect the delinquencies. And then remember too that consider payment plans with the owners. As part of the national survey from CAI, Community Associations Institute, and also the survey that our firm recently conducted, more owners are reaching out to boards to ask for payment plans if they can't afford to pay a past due amount, or maybe they're having difficulty because they've lost their jobs. We encourage boards to work with owners to try to get them on a payment plan and stick to it to help them through any difficult times that they're having. But remember, if you do a payment plan with an owner, make sure that they stick to it. We have a policy with our firm that if somebody enters into a payment plan with our firm, great. We want to do that as long as the board approves for us to do that. But once they breach the payment plan, that's it. There's no more payment plans. So we just have to communicate that to the owners up front so that it's not a situation of the owners on the payment plan for a month and then off of it for 6 months. And then, they're not doing anything regularly. That's not going to work in terms of how we run our business and how associations should run their businesses. Okay, so switching gears, just continue to be practical in your associations and, use your best judgment. So a really good example of this is your budget. We had kind of a crazy budget in 2020, right? I mean, we had a lot of things that we maybe didn't anticipate, additional cleaning, getting personal protective equipment for our employees, closing and opening common areas may have impacted your budget in some way. And so we really need to keep an eye on the budget for 2020 and then also be thinking about what are some surprises that we may continue to have in 2021. And so look for trends on your budget. If I was advising your board, if I was sitting there at the board meeting with you this month and I was giving you advice, really the two things I would be especially concerned about right now in your association are look at the delinquency list. And is it going up? Is it going down? The total dollars that are owed to your association. Look at the budget. What are we over budget on? What are we under budget on in 2020? Is this a trend that's going to extend into 2021? And when we're creating our budget numbers for 2021, we have to have some flexibility because, we don't know what the future is going to hold. And so I think the best way to prepare for that is to look at your numbers for 2020 and anticipate that at least the first 2 quarters of 2021 are going to be similar to what's occurred in 2020. You may even want to factor in more delinquencies. So if you're looking at the total dollars that are coming in the door to your association, you may want to anticipate that you may have a 5% additional amount of delinquencies in the first quarter and maybe 7 or 8% total more delinquencies in the second quarter. So these are just recommendations based upon, thinking about this issue, looking at national surveys, and frankly, having been through 3 downturns now in my practice representing associations. I've, had to pivot for associations 3 different times, and this likely will be our 4th pivot. So we just want to be smart about how we're approaching these challenges that associations are facing and making the best decisions we can. Okay, last thing. Let's not forget to build some community spirit right now in our community associations, right? My association is having a fun pumpkin carving drive where we are having a contest where all the residents are going to be entering into a pumpkin carving contest, and there are prizes of like $100 and $50 and $25 for the most creative pumpkins. Really consider doing that this year. It's going to be kind of a hard year for communities because we aren't going to be able to do some of the things that really bind us all together, like trick-or-treating and, the way that we would normally do it, or Halloween parties or block parties because some of the restrictions from the governor. So I'm encouraging all of you who are serving on your board, or if you're a management company representative that's listening here today, or manager, let's try to find ways to bring our communities together the next few months. We have Halloween, we have Thanksgiving, we have the traditional holidays in December. Let's try to find ways to bring our community together. Maybe have exterior decorating contests. Maybe if your association has a policy that you don't allow yard cards, and people are starting to put up happy birthday yard cards. If, there's a 8-year-old that has a birthday in your neighborhood, be a little more lenient than you would normally be on something like that. And another thing, be really mindful and careful of what's going on in our country right now, right? We have a national election, which is very divisive. We have some different movements within our country right now that people feel very strongly about. Be careful. If you're going to send a letter to an owner about a Black Lives Matter sign, be careful about that. This is not the time for you to be enforcing a sign restriction in your community, and we're advising our clients on this right now too. There's a lot of unrest, and let's not do anything right now in our country that's going to get us on the national news or potentially have a lot of negative press for your association that might impact your property values. So keep that in mind. Let's think of some ways that we can build community spirit. I know our guardhouse was decorated yesterday with Halloween pumpkins and, cobwebs and spiders. And, when we drove into our association last night, our children got excited about it. So, and so did I, frankly. It looked really cute. And it's the first time that's ever happened in the history of our association, which is great. So maybe you should think about having some firsts in your community to bring your community together during this time. Okay, let's switch gears. We're right on target for our time. We're almost at the halfway point of our presentation. Remember, just like any other presentation, we encourage you to continue to ask questions in the comment section, and I'll be sure at the end of the presentation to leave time to answer every question that's posted. The second topic we're going to be talking about today is federal laws. In addition to all of the state laws that board members and managers and owners need to be aware of regarding associations, there also are federal laws which you need to have on your radar so that you make sure that you're not violating any federal laws. And let's just state right from the beginning that serving on a board it's not easy because you're a volunteer. I can guarantee you that most of you have not spent your entire career getting ready to be a volunteer board member in an HOA or a condo. What likely happened is no one else volunteered, and you offered to, serve, and you didn't really anticipate that this was going to be a full-time job. But at times it can feel like it, right? And at times it can feel really challenging and difficult. And I know even I'm serving on my board right now. And last night we had an issue at our association, and it was upsetting. I will not deny it. And, we just have to move on, and we have to recognize, yes, there's going to be challenges when you're serving on the board. And you have to have a sense of humor, number one. And you have to have an understanding that you're not always going to know everything about this area of the law, because there's a lot to know. I mean, I've been practicing this area for 23 years. And sometimes there are still things that surprise me, or sometimes there are things that, I hear about that may be a new issue that I hadn't thought about. So this is an evolving area of the law. Okay, so let's talk a little bit about federal laws. What federal laws do you need to know about if you're on your board, a manager, or an owner in your association? First, I'd like to start out by saying we have a great cheat sheet on this topic. It's just called Federal Laws, and it's listed on our webpage. And that would be a great deep dive if you want more information than our seminar that we're giving here today. And also for those people who are more visual or who want to, revisit it after the seminar, that's a great place to look. So our webpage, mulcahylawfirm.com, has a copy of that cheat sheet. It's also posted in the comments section of this Facebook Live. Okay, so let's start out with the first thing that I hear very often. And I want to make sure that everybody's aware that this doesn't apply to 99.9% of associations. A federal law called the Americans with Disabilities Act, okay? And the ADA is a civil rights law, so the ADA is the abbreviated name for it. The Americans with Disabilities Act is a civil rights law that prohibits discrimination in places of public accommodation based upon a disability. Typically, community associations, such as condominiums and planned communities, are governed by federal and state fair housing laws and not the Americans with Disabilities Act, unless the association is a place of public accommodation. So, for example, the only way that an association would become a place of public accommodation is if they had like a clubhouse or a restaurant, which has general public access. In that case, then that area would be, subject to the Americans with Disabilities Act. So a question that I frequently get is, well, our pool is considered semi-public by our county. Would that make us subject to the Americans with Disabilities Act? No, it would not. So, a lot of times when homeowners may say you're violating the ADA, Americans with Disabilities Act, they're not using the right, law to, they're claiming that we're subject to the ADA. We're not. The only time, again, that you would be is if you're an association that has a public restaurant that, or a public area that the general public would be able to come to in your association. Okay, but the laws that you are subject to are going to be the federal and state fair housing laws. And we're definitely seeing an uptick in the number of fair housing claims that are made against associations. So it's really timely that we talk about what are some things that you need to be aware of if you're an owner, if you're a board member, if you're a manager, as you're navigating, fair housing issues. So, well, first, let's just start out by saying, what exactly is the Fair Housing Act? So the Fair Housing Act was created as part of the Civil Rights Act of 1968. And there have been multiple revisions to the Fair Housing Act over the years and many cases regarding associations and how it applies to, how the Fair Housing Act will apply to residents in an association. And so it basically prohibits discrimination, based upon a person's race, color, religion, sex, including sexual harassment, national origin, familial status, which means families with children, or disability, which includes mental and physical impairments that substantially limit one or more life activities. And some examples of that would be like blindness, hearing impairment, mobility impairment, HIV, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disability, head injuries, mental illness, and group homes. So let's just start out by saying this law is very broad and it covers a lot of different categories of protected classes. So, associations cannot discriminate against any of these protected classes. And so, how do we define like a disability? So a disability would be someone who has a physical or mental impairment that substantially limits one or more major life activities. A person who has a record of such impairment, or a person who is perceived by others as having an impairment. So a question that I often get is, okay, so we can't discriminate against people who have a disability in our community. Some disabilities are easier to spot than others. So for example, if you have an owner that has a sight dog, it's going to be more obvious that that person, is blind. Or if you have, an owner that's currently in a wheelchair, it's obvious that they have some sort of a physical impairment that would qualify as a disability. The less obvious disabilities are going to be emotional issues, such as like PTSD, or if they have some other emotional condition or mental condition that may not be as obvious, and or maybe an illness like MS or cancer. These are ones that are the trickier ones to navigate for boards. And so we'll give some examples as to what are some typical things that we've seen come up over the years, and give you some real life stories as to what's happened and how the association has either made a mistake or handled it properly, just so that we can hopefully help you not to make the same mistakes. Okay, there's two things that we have to do if somebody has qualified under, the Fair Housing Act as being a protected class. So the first example would be like a reasonable accommodation. The second example would be a reasonable modification. So let's give an example of a reasonable accommodation. And we see this often with condominiums. So let's say your condominium has a restriction in your CC&Rs that says that you cannot have any pets if you live in this association, like a dog or a cat, or maybe the dog or the cat has to be under a certain weight. And let's say that you have an owner that moves in and they claim that under the Fair Housing Act, they have a disability. And let's say that the disability is that they need an emotional support pet. And they're asking for the association to make a reasonable accommodation and allow them to have the emotional support pet. Now, whenever we are contacted by typically it's a condominium board on this issue, the condominium board typically is not happy about this because it's a pet-free community, or maybe they don't want large animals, and maybe the emotional support pet that the owner is requesting a reasonable accommodation for is a really large dog, and maybe all dogs are only supposed to be 30 pounds, or maybe no dogs. And so let's just kind of walk through the process here. So a reasonable accommodation is something that the association is required to make under federal law, the Fair Housing Act. And it's an alteration or a variance to the association's CC&Rs or rules, wherever the restriction is contained. And it requires the association to provide the disabled person equal use and enjoyment of his or her home. So, when these situations come up, the most common example of a reasonable accommodation, I think, would be the emotional support pet. I'm also going to give an example of the group homes next, but let's just walk through the example of an emotional support pet. So an owner shows up at the community with a pet that's prohibited in some way based upon your documents, and the board contacts the owner and says, you can't have this 80-pound dog or whatever it is. And the owner says, well, under the Fair Housing Act, I have a disability. I need an emotional support pet, and therefore I'm allowed to have this pet. And so the process that the association can follow and still be in compliance with the Fair Housing Act is to ask the resident for a letter from a medical provider to provide them with proof that they have a disability. And so you'll receive a letter from the medical provider, and the association, when they get that letter, oftentimes they will say to me, there's not enough information in the letter, or they haven't said what exactly their emotional disability is. we can't ask for additional information. If they provide that letter saying that they need an emotional support pet and it's written by a medical professional, that person is under the care of, the association has to make a reasonable accommodation for that pet. And we can't say you have to find a pet that's 18 pounds. If that's the pet that's our emotional support pet, we have to allow it. Now, a common question that I get, because boards sometimes get upset when they hear this, is, can we, still enforce any sort of pet restrictions? Like, can we require that the pet be on a leash? Yes, but typically the sight dogs and hearing dogs are never on a leash. So you need to know that we wouldn't be able to require it for those dogs. And they're obviously trained service animals, so they shouldn't be, running off away from the resident. But for an emotional support pet, absolutely, you can require that the pet be on a leash at any time when it's on the common areas. We can require that the owner clean up after their pet. If the pet is barking and creating a disturbance to other residents, which is a nuisance, of course, we can still enforce our nuisance restrictions against that owner. So that's just kind of the natural progression of how these issues come about. And it can sometimes be frustrating for boards, but you just need to know that, hey, this is what the law says. Okay, let's talk a little bit about, group homes. This is another thing, that's typically a big question, more so in planned communities than it would be in condominiums in Arizona. So what if your association finds out that an owner wants to convert a residential home into a group home? What rights does the association have under the Fair Housing Act? And so the Fair Housing Act of 1988 expanded protections for individuals with all types of disabilities. Thus, it banned the prohibition of group homes, which are defined as a group of unrelated disabled individuals living together in a dwelling in community associations. So bottom line is associations cannot prohibit group homes in your association. What the association can do is we can request documentation from the group home, the operator of the group home, the owner of the property, that verifies the existence of the disability that the group home is related to. And not all group homes are protected under fair housing laws, so it's important that you know that. You have to separate the legitimate ones from the illegitimate ones, and you have to talk with your trusted advisors when you find out what type of group home it is. But typically the group homes that we see are going to be group homes for the elderly, group homes for disabled, and sometimes we'll see them for current addicts and current substance abuse abusers, and those are all okay under the Fair Housing Act. The ones that would not be okay would be like those with bad credit or sex offenders are not considered as having a disability under fair housing laws. And so it's important, that we accept and understand that under the Fair Housing Act, we cannot prohibit certain types of group homes. There are some steps that the group homes have to take before they can officially become a group home in your neighborhood. They have to register with the city that the group home is located within. And that process, the association can verify that they have registered. Some cities have restrictions as to how many group homes you can have in a certain geographical distance, like a mile radius or whatever their specific geographical distance is. So you may want to inquire by that if you're seeing a number of different group homes in your association. One just kind of practice pointer that I can tell you is that typically before the group home comes into your neighborhood, owners, neighbors, the board typically are upset about the change of use of the property. And lots of times the boards will say to me, our CC&Rs say that you can't run a business out of your home, and this is clearly a business. Why can't we enforce the CC&Rs? It's just one of those things. It's a federal law that we have to comply with. And even though it is a business, it's the federal law under the Fair Housing Act trumps that. And so you can't enforce that restriction. But what you can do, just kind of like the emotional support pets, are that you can enforce any sort of other use restrictions. So they shouldn't be having parking that would potentially, be parking all over the streets, creating additional parking, or there shouldn't be any additional noise for your community. And so just like that, any nuisance provisions can still be enforced against a group home, and then any violations, other violations like trash can violations or parking violations, those also can be enforced. And from our experience, group homes are good residents in communities. We send very few violation letters to group homeowners. They pay, they maintain their property, and for the most part, there really are no issues with it. It's most associations can't even detect it's a group home after the group home is established and running. So that's important to know as you navigate through this process if you have one of those in your association. Okay, so we talked a little bit about reasonable accommodations, right? And we have to make reasonable accommodations for, anybody that has a disability, whether it's a emotional support pet, whether it's a service animal or a group home. Now let's talk about modifications, reasonable modifications. What types of things do we have to actually change in our community if somebody is requesting a modification to, like, our common areas, for example? And really the most common examples I see of this would be, let's say that you have a pool in your association, but you don't have a pool lift. And maybe you have a handicapped resident who qualifies as a disability under the Fair Housing Act, and they're asking for a pool lift to be installed. Or maybe you have steps to get into your clubhouse, and there's no ramp that was built for somebody in a wheelchair to be able to access your clubhouse. Or maybe your mailboxes are located in an area where, the person that's in a wheelchair is unable to reach their mailbox or unable to jump the curb to get up to the mailboxes. These are all really common problems that we hear about as general counsel for associations. So how do associations navigate this when these type of issues come up? So this is an important distinction because a lot of associations know that they have obligations under the Fair Housing Act, but they don't really understand who pays for these modifications. So I want to make sure that we make that really clear today. So the first thing to think about is, what is a reasonable modification? It's a modification or an alteration to the building, common elements, or limited common elements to afford the disabled equal use and enjoyment of their home, or of the common areas, or of being able to access their mail at the mailbox. So fair housing laws on a state and federal level require the association to allow the modification to the common elements so that the disabled person can use the facility. So, point number one is, if they qualify as somebody that is disabled under the Fair Housing Act, we are required to allow them to make the modification. Now, there are a couple caveats on that, but let's, give an example. So let's say that somebody who is confined to a wheelchair wants to have a ramp installed in the association's gym so that he or she can use it for exercise. So the request comes in from the owner or the resident. It's provided to the board. The board will, maybe need to ask for clarification regarding the person's disability. And the board should also ask what specifically they are requesting. Like, do you want to have like a ramp that is permanent? Do you want to have a temporary ramp that you bring with you and just pop out and put up, get through the step or the doorway? And so that's important clarification. And then it's determined, the board has to look at each on an individual basis. Is this something that they will allow? Are we going to require that a contractor, that's licensed and bonded, install this, construct it and install it? Are we going to have to see plans before it's installed? Or is it as simple as the person just brings, like a ramp that they kind of keep in the back of their car and they just pop it in there and when they go up and pop it in there when they go down, it's no big deal. So you got to find out more information on that. We have to be reasonable when we're evaluating these. So reach out to your trusted advisors and get their advice. Who pays for the modification? This is the key thing, is that the person that is requesting the modification pays for the modification. So if the association gratuitously decides to pay for the modification, of course, they certainly can. But this is not something that the association can be forced to pay for. So that's important to discuss. And what we want to do is, I mean, we see these in all different kinds of circumstances. Let's say that somebody wants to put a handicap ramp at the front entrance of their home, or we see it, like I said, in the common areas, or the pool lift. We have to really think about long-term how this is going to impact the association. So let's say that somebody wants a lift at the pool. That's a very expensive dollar item. And so they provide that they have a disability. Your board's going to have to determine if that's something that the board's going to pay for gratuitously, or if it's something that you're going to require the owner that's requesting for it to pay for it. And remember, the board is not required to pay for the reasonable modification, but you can choose to if you so desire. If the owner pays for it, you got to think long-term about maintenance of this, because, the pool ramps over time, the paint chips, they rust. And so have a maintenance agreement at the outset on that. And our firm can help you draft a quick one-pager on that. But the key terms to discuss are that it needs to be it needs to be able to function, long-term. If there's any sort of like let's say it stops functioning, it would need to be removed by the owner. There needs to be a plan if the owner sells their unit or, doesn't live there anymore. Will that owner be taking it out at their expense and replacing, any damage to the pool decking, etc.? So all these things should be thought out in advance, because what sometimes happens is that the board allows the pool lift to be installed at the pool. The owner moves on to a different association or somewhere else to live, and now that pool ramp or the pool lift is there, but it is an eyesore now, or it's not even functioning anymore, and now we have to incur the expense to take it out or have it maintained. So these are just all things that you should be thinking about at the outset when you're evaluating a high-ticket item like that as a request for a reasonable modification to your common areas. Okay, let's talk about two more important things on the Fair Housing Act, and then we're going to get right into our question and answer period. Let's see. Okay, so let's talk a little bit about the Housing for Older Persons Act of 1995. So some associations are classified as a 55 plus or an age-restricted community. And typically you'll know that because maybe it's on the sign in the front of your entrance of your association, or maybe it's listed right in the first page of your CC&Rs for your community. And you can continue on. It's just a special exception that was made under the Housing for Older Persons Act of 1995 that allows associations to restrict ownership or residency in an association to 55 plus or age restricted. And so in order to be a 55 plus community, the association has to maintain that at least 80% of the occupied units have at least one person who's 55 years of age or older living in that unit. So how do we do that? Typically, you're going to have, like a census. We'll talk about that in a minute. Usually associations are doing that about every 2 years. But so the first thing you have to be a 55 and over community is you have to have at least one person residing in 80% of the units who's 55 years of age or older. You have to publicize and adhere to policies that demonstrate an intent to be housing for older persons. So that's probably why you have something on a sign at your community that says we're proud to be a 55 plus community, or something similar language to that. And then lastly, you have to comply with the rules for verification of occupancy in accordance with this particular law's requirements. And so what the law says is that associations have to survey residents for age verification every 2 years. And if you fail to conduct this survey, it could jeopardize the association's 55 plus status. So an age-restricted community, of course, can allow people who are under the age minimum to visit and stay on a limited basis. You'll have to look at your individual CC&Rs to determine, what they say about maybe residents that come to visit who are under the age of 18. Typically, it's like a maximum of 30 days in any 12 months or something of that nature. You can enforce that, but the occupancy still must remain with the restrictive minimum of 80% of, at least one person who's 55 years of age or older must be living in that unit or lot. It's important to note that the 55 plus occupancy requirement is related to occupancy and not ownership of a unit. So what are the most typical questions that we get under the Housing for Older Persons Act, which is a part of the Fair Housing Act? Well, maybe if you're a 55 and over community, you'll get a request from somebody who's 45 or 53 or 54 and a half, and they want to occupy a unit or lot in your association or buy with the intent that, okay, in 6 months I'll be 55 or whatever, however many years it is. And really, you, as a board, you have to look at that on a case-by-case basis, because you have this like 20% wiggle room under the Fair Housing Act, the 55 and over Housing for Older Persons Act. But typically associations are saving that 20%. So the 20%, remember you have the 80% that have to have one person who's 55 years or age or older. We save that 20% for unique situations that come up under the Fair Housing Act. So for example, let's say that the one resident, husband and wife own a lot in a 55 and over community, and the husband is 58, the wife is 50. The husband passes away unexpectedly. We now have an occupant in that unit or lot that's age 50 and is not meeting the age requirements, for a 55 and over community. We would push that person into the 20% category that would be, allowable to stay in the community, obviously, because we're not going to ask that person to leave. They've lived there before. And so as you're evaluating these new requests that come in for 55 and over community, remember that you really need to be mindful of how close you are to that 20%. And you should be saving that for circumstances that come up, like the example I just gave you. And reach out to your trusted advisors and talk with them about that if you have questions about, hey, should we allow this person to live here? Another really common problem we're seeing with the 55 and over age-restricted communities is, let's say that somebody buys it and maybe the person who buys it is 55 and over. And again, we got to remember, it's not the record owner has to be 55, it's the occupant. And maybe they have their ASU grandson staying there, right? And this person is clearly not meeting the 55 and over requirements. So those type of things we need to evaluate. What did the CC&R say about how long that person can stay? We have to evaluate, is grandma there with him and she would therefore meet the 55 and over requirement? These are all different comments that come up and questions that come up as we navigate the age-restricted communities. So keep that in mind. Reach out to your trusted advisors, your law firm, your management company as you navigate through these different questions. Okay, last but not least, we have to talk about what sort of liability do community associations have if there's any sort of a harassment of a protected class. So we do really need to be careful on these. Many years ago, we had a case in our office where an association passed a rule. It was a high-rise actually in downtown Phoenix. And they passed a rule saying that no children under the age of 14 could get in an elevator in the association unless an adult age 18 was with them. And what was happening, I've got kids, I get it. What was happening is that the kids were coming home from school and they were pushing all the buttons in the elevator, and the elevator was broken, on a pretty regular basis. So they thought, the way to do this is to, pass this rule, then the kids won't be allowed in the elevator unless their parents are there. This will stop all the damage. But really the reality of this was that it now required, kids to, climb 20, flights of stairs to get home. And of course, one of the residents in the community filed a complaint with the Attorney General's office to, claim that the association was discriminating against the association. So I think what you need to be aware of is that, there have been, adjustments to the law since 2016 where it talks about, where there's harassment, we're creating a hostile environment of harassment, and we have to be very careful if we think that there is some sort of a harassment going on of any of these protected classes. So if you have a resident that's claiming that, please reach out to your management company, to your attorney, talk about it, talk about whether the association is being reasonable. I will say that in most circumstances where the association is pursuing an owner for a violation and then the owner replies back, you're only creating this violation because, I am a protected class and you're discriminating against me. Our experience has been that is typically not something that there is no harassment happening. What's happening is that the owner is not complying with the restrictions in the community. But just be careful if you have an owner that's claiming this, because there is liability for the association if it can be proven that, in fact, the association is targeting a certain protected class. You need to be mindful of that as you're, handling different violations, et cetera, in your community. Okay, so let's switch gears and talk a little bit about the questions. Looks like we're just finishing up right at just 2 minutes before the hour mark, so that's great. And it looks like right now we have about 6 questions. So the first question is from Duncan Thompson. If due to COVID-19 impacts, a homeowner is being delinquent in assessments, is it advisable to accept partial payments? It just depends. So I think what you need to do is have a plan. So let's say that a homeowner comes to you and says, I just lost my job and I, am not going to be able to get my unemployment benefits for however many weeks. And would it be possible for me to, either not pay my assessment this month and pay double next month, or can I just pay $100 now and then, when I get back to work or whatever, I'll make up the difference? Yes, of course, you can enter into, some sort of an agreement with homeowners like that. But just remember, this can't be a long-term solution. This is a temporary solution. So make sure that this is not, you can, pay half of your assessments for 3 years or something like that, because it's going to be really hard for that person to get caught up. So I think it's okay to accept partial payments as long as there's a plan for them to get back on track to pay back what they, were unable to pay when they paid the partial payment, and then get back to paying the regular assessment. Does the ADA apply when we rent our clubhouse to outsiders for parties, wedding receptions, church services that renters are not residents of the community? That question is from Tom Corn. That's a really good question. So yes, it probably does. So, I think the thing that you have to look at are residents sponsoring the clubhouse activity. Like in my association, a resident has to sponsor the party at the clubhouse. So therefore, it likely wouldn't be a party that's just open to people just walking in off of the street that have no connection to your association. But what I will say is that, if you are, publicizing like in your local newspaper that's not associated with your association, that wedding receptions can be held to the general public at your association in your clubhouse, then yes, you may have to comply with the ADA. And, there are some pretty strict requirements for that, such as accessibility requirements. Your bathrooms would have to be ADA compliant, your doorways, etc. So you may want to think about, is the income that you're generating from, some of these general public things, if it in fact is a general public thing in your community, you do have liability if someone raises an issue that, hey, this facility isn't ADA compliant. And so maybe the income that you're generating from that may not be worth it for the liability that you have on that. Okay, from Danelle Mercado, how do you handle comments and questions that come into a board meeting electronically after the open forum has passed in a virtual meeting? Oh, good question, Danelle. Okay, so it just depends on how your meeting's going. So let's say that this is a super contentious meeting. I was on a meeting last night that, everybody was fighting. And we needed to get the meeting under control. It was obviously conducted in a virtual setting. And people were talking over each other, and, there were comments flying in the comment section. And so what I advised the board in that situation was, we need to get through our board business this month. And so we had the homeowner forum at the beginning. It was very long. And then we went into the regular portion of the meeting. During the regular portion of the meeting, I suggested to the board that you get your business done. Before the board took any formal action on an item, it was opened up that the residents could make one, 30-second comment on any of the items that were being approved, like last month's meeting minutes, I think was one of the items. And I think we approved the treasurer's report. But other than that, it was closed to just the board members talking. But in other situations, your community. In other situations, if it's not a contentious meeting and you don't have 100 people on the call, and then you're able to be a little more flexible. And if somebody asks a question electronically, Certainly you can allow them to talk. It really just depends on what's working for your association. But if you're finding that the comments and questions that are coming in electronically are sidetracking the board's ability to get things done, then you really need to limit any comments to only during the time period before the board takes formal action. So how that would work is somebody makes a motion to approve something, there's a second on the board, there's a discussion period of the board, and then during that discussion period, if any owners want to make a brief comment on the item being discussed and voted on, then they could do that. So you just have to look and see what works best for your community. Rick Marine, great to see you, Rick. Thanks for being here. If we are an age-restricted community, 55 plus, can we deny ownership for a group home if the owner does not qualify? Okay, this is a good question because I wanted to incorporate this somehow into my presentation today. So just to answer your question specifically. So if you're a 55 and over community and somebody wants to create a group home in your community, and remember, it's not the owner, it's going to be the residents, right? So let's say that they want to have a group home for maybe developmentally disabled teenagers. And it falls under the description of a protected class under the Fair Housing Act. So the question is, if our community requires that we have, occupants, at least one occupant that's 55 or over, and we have to have 80% of our units, that are in that category, can we say no to the group home that clearly is going to have occupants that are under that 55 age? My answer to you on that is that's a tough one, but my opinion is that the Fair Housing Act, this would be one of those times where you have to make a reasonable accommodation because the Fair Housing Act trumps your association's documents. And, another situation, there was a case, this is what I really wanted to incorporate into our presentation. Maybe 5-7 years ago, there was a case in Northern Arizona where very similar to these facts. So it was actually a resident had a disabled child living with them. And the child was under the age requirements, pursuant to the documents. And I can't remember exactly what it was, but I think it was definitely a child under the age of 18, and they were handicapped. Definitely it fell under the Fair Housing Act. And the association sued to enforce the restrictions, the CC&Rs, because that child was living in the property with the parents or the grandparents. I can't remember who it was. And the parents or the grandparents, they met the age 55 requirements. And what the court in that case said is that the association is required to make a reasonable accommodation under the Fair Housing Act. And the association, was required to allow that. So be really careful on those situations. Those are, heart-wrenching. You have to get advice from your legal counsel when you're facing one of those questions, because we could have saved the association a lot of time and money and legal fees and not been involved in a lawsuit. We would have told you up front, hey, you can't do that. You have to allow it and make a reasonable accommodation. And remember, just in terms of the cost of these fair housing cases, what the typical procedure is that the owner will send a letter to the association saying, we're being discriminated against. And I think at that point we have to determine, like 95% of these are not actual discrimination cases in my experience. What's happening is the owner is violating the documents in some way, and they're not entitled to a reasonable accommodation. And they are, let's say they're not maintaining their property, or let's say that families with children aren't supervising their children at the pool, and the rules say that they're supposed to have an adult with them. I mean, there's all kinds of examples of this. And then the owner gets the violation letter and they say, you're discriminating against me because of this. I think right at that point, when you get that first letter saying you're discriminating against me, association, that's when you need to reach out and talk to your lawyer and make sure that, what you've done so far has been legitimate and that you have a strong case, if the owner does proceed forward and if you do try to continue to enforce it against the owner. And let's say the next step that the owner, if they feel that they're continuing to be discriminated against, the next step that the owner will follow is they'll go to the Attorney General's office in Arizona and they'll file a complaint. And my experience has been that, if they file a complaint, it will be investigated by the Attorney General's office. So then we'll get a letter or we'll get a phone call from the Attorney General's office and we'll have to do a response. as to what our position is. And sometimes there's even formal questioning or depositions of people. So that first time that somebody says they're being discriminated against, that's a really important time for you to be reaching out to your attorney and getting advice, because those fair housing cases where it goes through the Attorney General's office and they blow up into, mediations and potentially litigation with the EEOC, those are expensive. And sometimes they're covered by your insurance, sometimes they're not. So you want to make sure you're making good choices at the outset when that comes up. So really good question, Rick. Scott LaBounty, can an HOA require documentation that support an animal is professionally trained? So great question. I don't believe that they can, especially like in the example of a emotional support pet. There is no formal training typically for an emotional support pet. Now, a sight dog or a hearing dog, I think it would be overkill if the association was asking for some special documentation because to see if it in fact was a service animal. Typically when you get the note from the medical doctor describing the person that has that type of a disability, it's going to be very obvious to you that they need a sight dog or, a special dog maybe for seizures or PTSD or something like that. Okay, next question is from Neil. Does a city have any liability for the cost of maintaining our lakes that receive runoff from city streets? Okay, so this is one on a little bit different topic. We have no idea of pollution from contamination of various items, oil, dirt. We pay for a lake management company to help clean up to keep water up to par. Okay, so good question, Neil. So I don't know the exact answer on this. I guess it depends on if there's proof that there's liability, right? So I think what you need to do is, all of these lakes that we have a number of communities in Arizona that have lakes as part of their amenities and their common areas. And so you have lake maintenance companies. And so what you need to do is reach out to them and determine what's causing, contamination or what's causing pollution or, what is the issue with our lake, and have them provide an opinion. And once you get that opinion, then I think you need to take it to your legal counsel or take it to the city attorney at the city or maybe a contact at the city and discuss whether or not this is something that the city, could potentially be responsible for. In my experience working with hundreds of HOAs that have lakes, I have never seen that be an issue. I've never seen an association claim that something that the city was doing was causing contamination. So you just need to know that. I haven't heard that, but reach out to your lake maintenance company, get more information. And then once you get the information, reach out to your trusted advisors to see what's the best course of action. Okay, last question is from Mark Yost. The board voted down an update to our clubhouse, which is sorely out of date. A former property manager told me that the board doesn't have the authority to vote down something that improves the community because it affects the value of the entire community. What are your thoughts? Honestly, if I had $1 for every time I got this question, I probably could retire. So these type of things happen all the time in communities where maybe homeowners vote down improvements to the community, or maybe the board doesn't want to spend money to upgrade the front entrance or the clubhouse or the tennis courts or whatever. These are very common issues that associations face. And I'm sure that the board has some reasoning or rationale for why they, chose to not proceed forward on this at this time. You probably want to reach out to them to talk about that, get more information. Maybe they want to create a 5-year plan to come up with a solution down the road. I don't know your association, so I have no idea. Maybe they don't have the money right now. Maybe they think the timing's bad because of the pandemic. Maybe they can't get a loan. I don't know all the different factors that they're looking at. But what I would say is the board has a fiduciary duty and needs to make decisions that are in the best interests of the community. So of course, if your association is, not being maintained and everything's falling apart and property values are tanking, the board does need to be coming up with a plan. But if it's something that, hey, we can't recover the chairs in the clubhouse right now just because there's uncertainties with the pandemic and we don't have money to spend $400,000 to renovate the clubhouse right now, I think that's understandable in this time period. And so I think reach out to them, find out the reasons. If you disagree, remember, you always have a right as a board member to run, or as a homeowner, to run for the board. So that's how I got on my board. I wanted to make positive change, and so that's a great suggestion. Think about how you can contribute. And once I give you the reasons, maybe a proactive thing to do would be to volunteer to help look into whatever the issues are or the obstacles that they're facing, and give them some ideas on how they could overcome them. So if they say they don't have money, maybe you could do a study on what would be some different ways that they could raise money to pay for this, or get a loan from a bank. Is that possible for your association? Look into the different options to help them do their job. Thanks again for being here today. I hope everybody stays safe and healthy, and I look forward to seeing you again.